Hello and welcome to today's webinar. This webinar is focused specifically at qualified lawyers and in particular at qualified lawyers who are thinking of becoming a solicitor in England and Wales. Although we will also cover the legal work that you can do as a qualified lawyer using your home title. My name is Maxine Waugh and I'm Head of Education and Training at the SRA, and I'm joined by my expert colleagues today, Chris Young, Tim Pearce and Manira Bibi. But before we start, let me just go through a couple of small points with you. We can take questions throughout this webinar, so please do send them in the link below the webinar if you have any. We will try and cover as many as we can, but I should say, just to manage expectations, we have had a lot of interest in this webinar and we have already had quite a lot of questions sent in. So we will try and cover as many as we can, but as I say, I don't think we'll get through everybody's questions. And also we can't answer questions about very individual specific circumstances. Again, we've had a lot of those questions, so we won't be able to answer those, but we will do our best to help you as much as we can. And then also at the end of the webinar, I'll remind you again, but we would like your feedback on how the webinar's gone today. Again, there'll be a link below the webinar for you to fill out a feedback form for us. So we would appreciate it if you would do that at the end of the webinar. But anyway, let's get started. Let's start with you, Chris, and just cover the basics. So as I've said, this webinar is for qualified lawyers. What do we mean by a qualified lawyer?
A qualified lawyer is someone who holds a qualification which gives them the right to practice law, and that can either be here in England and Wales or from another jurisdiction. So it includes other types of lawyers here in England and Wales, such as barristers and legal executives, but it also covers lawyers who are qualified in other countries.
Thank you, Chris. And what about qualified lawyers who want to qualify as a solicitor in England and Wales? Because I expect most of the people that are watching this webinar today are in that position.
Well, there's a few things that they need to have to qualify as a solicitor in England and Wales. Firstly, a qualified lawyer needs to hold a degree or equivalent level qualification. In most cases, a qualified lawyer will have done this as part of their original qualification in their home jurisdiction. The requirement to hold a degree is flexible, though. The degree does not need to be in law, but it includes qualifications in the UK or overseas that are not degrees, but are taught or assessed at an equivalent level. The second requirement is that you must pass the solicitor's qualifying examination, which we'll refer to as the SQE. In this webinar, we'll explain more about the SQE. But finally, the last thing that a qualified lawyer needs is to meet our requirements for suitability to become a solicitor. We require high standards of conduct from solicitors, so we run checks to ensure that everyone who is admitted as a solicitor is suitable. For example, we check for criminal convictions, and we also make checks with your home country's bar or law society.
So I'm just going to repeat this just to be clear, because we do get lots of questions about this. There is no requirement for a specified period of work experience for qualified lawyers who want to qualify as solicitors in England and Wales. We will expand on that a little bit more when we talk about exemptions later in the webinar, but the basic requirement is there is no requirement for a qualifying work experience period for qualified lawyers. However, there is a requirement, as Chris has said, to take the SQE, the Solicitor's Qualifying Exam, which all aspiring solicitors have to take in order to qualify as a solicitor in England and Wales. So can you tell us, Chris, a little bit more about the SQE and what that entails?
Yes, so it is the single robust set of exams for everyone who wants to become a solicitor. It is an assessment, not a course of study. Candidates can choose how they prepare for the SQE, and there is information on our website to help candidates think about the options for preparing for the SQE. The SQE tests both legal knowledge and practical skills, and it is assessed at the level of a newly qualified solicitor. To reflect the fact that it assesses both the knowledge and skills, it consists of two parts, SQE1 and SQE2.
Thanks, Chris. So you said it's SQE consists of two parts, SQE1 and SQE2. Tell us a little bit more, Chris, about SQE1. It's a test of functioning legal knowledge What does that mean, and what does the assessment look like if people are taking SQE1?
Yeah, so the word functioning means that the SQE exams test more than just academic knowledge of the law of England and Wales. It tests candidates' ability to identify legal principles and apply them to client problems and transactions in the way that a solicitor would in practice. The SQE1, the assessment that is a computer-based assessment consisting of two 180 question exams, totaling 10 hours. The two exams cover the main areas in which a solicitor works, including business law, criminal litigation, civil litigation, including disputes in contract and tort, property transactions, and wills and probate. SQE1 also contains questions throughout which raise issues of professional ethics and conduct, such as acting with integrity, encouraging equality and diversity, and acting in the best interests of your clients. These questions are not flagged up, so candidates would have to spot the ethical issues like a solicitor would in practice. And if you're not in the UK, you can take the SQE1 in many locations around the world. There is up-to-date information on where it's available on our website.
Thanks, Chris. So that's SQE1. It's a computer-based multiple choice question exam. Just to be clear, SQE1 must be passed before you can take SQE2. But if you do pass SQE1, then you can go on to take SQE2. So can you tell us, Chris, about SQE2?
Sure. The SQE2 assessments consist of 16 written and oral tests totaling 14 hours. Each of these 16 tests is designed to simulate the key tasks carried out by solicitors. The assessment tests practical legal skills and functioning legal knowledge equally. And again, there are unflagged ethical questions throughout the assessment. You can sit the written part of SQE2 without being in the UK, but the oral SQE assessments can only be taken at specific venues in England and Wales.
Thank you, Chris. I'm going to give you a rest now, Chris, and I'm going to move on to Tim to talk about exemptions. So, Tim, Chris has already explained that qualified lawyers are required to take the SQE. Those are the basic requirements. But some qualified lawyers are eligible for exemption from parts of the SQE. And we do get lots and lots of queries about this. Can you explain, Tim, the rules on exemptions for qualified lawyers?
Yes, yeah, because we recognise their qualifications and their experience, we allow qualified lawyers to apply to us for exemptions from the SQE assessments. And you can apply for an exemption from the whole of any SQE assessment. For example, you can apply to be exempted from the whole of SQE2. But it's really important to understand and know that you cannot apply for an exemption from just a part of an SQE assessment, for instance, part of SQE2. You apply for exemption from the whole thing. Another important thing to understand is that all qualified lawyers of all jurisdictions in the world are eligible to apply for an exemption. But that doesn't mean that an exemption will always be granted. There's a difference between being eligible to apply and actually the grant of an exemption. When a qualified lawyer applies for an exemption, they need to demonstrate that they meet some very important criteria before we can actually grant that exemption. And my colleague Munira will cover this in more detail later on, but the overall principle that's important to understand is this, that in order to be granted an exemption, your application as a qualified lawyer to us must demonstrate that your qualifications and your experience reach the same standards that are assessed in the SQE assessment that you're seeking exemption from. And we will explain that as we go forward in a little bit more detail. But before we move on to that, there's another very important principle to understand, that we can't grant anyone an exemption from an SQE assessment that you have already failed. And that's because failing an SQE assessment is a clear indication that that person does not meet those standards that we require. So if you failed the SQE, then you must retake it and pass it in order to be admitted as a solicitor. You are not eligible to apply for an exemption.
Thank you, Tim. Let's talk, Tim, a little bit more about SQE1 first in detail in terms of exemptions. Now, we can't stress enough how hard it is to actually be granted an exemption from SQE1. Most qualified lawyers will not be able to get an exemption from SQE1 because their qualifications and experience will not be equivalent in content and standard to the SQE. And in fact, just to explain that further, we've only granted one SQE1 exemption in the 3 years since we started considering exemptions. So do you want to just expand on that a little bit more, Tim, please?
Yeah, that's right. That exemptions from SQE1 are exceptionally rare. And that's because it's extremely unlikely that a qualified lawyer from qualified in your jurisdiction would be able to demonstrate what Chris has explained to be functioning legal knowledge at the standard of a newly qualified solicitor in relation to every single one of the subject areas assessed in SQE. There's the fact that those subjects assessed in SQE1, they cover almost the full breadth of the law in England and Wales. So that goes from advising a client in a police station and having the knowledge to be able to advise them about their criminal law and their rights, through to, say, the knowledge required for someone to carry out a transaction where someone buys someone else's house or land. It's that functioning legal knowledge that it is very unlikely that a qualified lawyer of another jurisdiction will have. And so if you are thinking about applying for an SQE1 exemption, you think, I have got that sort of knowledge, you can look on the links at the end to see the SQE1, what we call the assessment specification. You can see all the subjects that it covers and the standard that it is at. And I would advise you to do that first before doing anything further. And if you still think that maybe there's a possibility, then you can contact us and discuss it with you. But generally, we don't want to waste anyone's time with an application that is not going to succeed.
Thank you, Tim. I think that's really clear. We've had a question in, Tim, that I'm going to ask now, because I think the answer to this is fairly straightforward. We've been asked, does in-house experience count towards the exemption requirements?
Yes, it can. Broadly, what we ask is for exemptions, we are looking for experience, the experience requirement, which Manira will set out the actual kind of details that need to supply the evidence. But broadly, experience as a lawyer can be gained either practicing in private practice or in-house, as long as you are practicing as a lawyer, it's actual professional experience as a lawyer.
Thank you, Tim. So I think it's clear that the advice on SQE1 exemptions is to think very carefully about whether or not you meet the requirements. Let's move on then to SQE2. We have granted a lot more exemptions from SQE2 than we have from SQE1. What does someone need to do to get an exemption from SQE2, Tim?
Right, well, the process for applying for SQE2 exemptions is very different. Broadly, what we do, we can take account of the legal skills that qualified lawyers already have. Remember, SQE2 is a test of skills. And so by virtue of their qualifications and their experience in the law of their home jurisdiction, qualified lawyers will already have many of those skills. But of course, we need those skills to be demonstrated to us. Now, we've already considered applications from lawyers from a large number of jurisdictions around the world, and we've been in touch with the regulators in each of those jurisdictions. And that has enabled us to provide information on our website, which actually gives you a kind of step-by-step process to help you structure and submit your application. And there's two main things that you need to bear in mind when making making an application to us. So what the first one is that you need to have the same rights to practice in all the areas of law that a Solicitor of England and Wales does. And broadly, that's all set out on our website, but they are the principal areas such as criminal and civil litigation, probate practice, in other words, transferring an estate of a dead person to their beneficiaries, and the process of transferring land, so which we refer to as property practice, sometimes referred to as real estate. We look at those practice rights and say, well, these will equate to the skills that are needed in order to do things like to carry out a case in court or interview a client. The second thing we look for is whether you have got experience of practicing law. Now, as a qualified lawyer, remember, you don't have to do a pre-qualification period of work experience as a UK or England and Wales candidate would. But in order to get an exemption, we are looking for whether you've got experience of actually practicing law, and we would normally expect you to have 2 years of legal professional work experience. So broadly, what you then can do, those details for your jurisdiction, you can look at our exemption finder, which Monira will explain in more detail, and that will help you with the details for your jurisdiction. If your jurisdiction doesn't appear, you can still apply, but we can assist you with that process.
Thank you, Tim. So just to be clear, Tim, qualified lawyers do not need 2 years work experience as a requirement for the SQE route. However, if they want to apply for exemption from SQE2, they would need to have 2 years legal professional work experience, either as part of their home qualification or after they've qualified, in order to be eligible to get that exemption.
That's exactly right, yes. Unlike non-qualified candidates, qualified lawyers are not required to complete that qualifying work experience, but in order to be granted an exemption from SQE2, a qualified lawyer must show they have those 2 years experience in legal practice, and that can be gained either as if it's a pre-qualification requirement of your jurisdiction. For example, if in your jurisdiction you have to serve in a training contract prior to qualification, that is a common system, particularly in European countries, where you would normally serve a 2 or more year period of pre-qualification work experience under the supervision of a lawyer. And again, that can be in-house as well as private practice. Or it could be a post-qualification experience you've gained in practice as a lawyer since qualifying, which many lawyers around the world will gain their experience post-qualification, where there's no pre-qualification requirement in your own jurisdiction.
Thank you, Tim. We've had a question in. I think you pretty much covered it, Tim, but I'll ask you the question anyway. So the question is, the qualifying work experience for the purposes of gaining an SQE2 exemption. The question we've had is, does the title of the work, the position that the person doing the work, does the title matter, or is it actually about the work that's done? And I think you've explained it's about the work that's being done.
The thing is, the work has to be has to be done either as part of your qualification process, as I've explained, pre-qualification in a training contract. You know, a typical example is, for instance, Danish advocates do 3 years pre-qualification experience, so they can count that. That's required. You cannot become an advocate unless you do that. In other jurisdictions, sometimes there is no pre-qualification work experience requirement. In that case, you must gain your 2 years as practicing as a lawyer of that jurisdiction. And you could say, well, I've got other work experience which is in the legal field, and it's, you know, it's relevant. But the problem is we do not know that that work is at the right standard. And we come back to this point I've mentioned about we need to know that your work, your experience is at the standard of the SQE2. So for that reason, if you do work experience which is not under a professional title or qualification, we can't count that towards your 2 years.
Thank you, Tim. That's really helpful. I'm going to give you a rest now, Tim, and I'm going to move on to Manira. So Manira, you deal directly with exemption applications, and we do have guidance and tools on our website to help people who want to apply for exemption from SQE2. And this information tells people whether we've already looked at their qualification. Can you tell us a little bit more about that, please, Manira?
Yeah, so the SQE2 Exemption Finder is a great tool, and if you want to apply for an SQE2 exemption, please check this on our website. There is a list of jurisdictions with detailed information on what is required for your qualification. So, and if you cannot find a jurisdiction, it just means that we haven't assessed that qualification yet. So for brand new qualifications, if you do meet the definition of a qualified lawyer, you can still make an application. But what you'll have to do is provide as much information as possible about your regulator, because we will reach out to them separately and then assess that qualification. What you'll have to do as well when you're making the application is add your jurisdiction in MySRA. And this makes sure that the system recognizes your jurisdiction when you make the application. And when it's added to your record, it will also allow individuals to be able to see the exemption application. So there's two types so there's agreed exemptions, which you've already spoken about, and this only applies to jurisdictions where we have assessed the qualification and they have the same practicing rights as solicitors of England and Wales, and they have a 2-year mandatory pre-qualification work experience. There's also individual exemption applications where individuals have the same practice rights, but they'll need to demonstrate some post-qualification legal work experience. Now, the exemption finder will detail what evidence we need and the length of experience needed. So some jurisdictions might have 12 months that you need to demonstrate, and some may have 2 years that you need to demonstrate, but you'll have to check the exemption finder to see what the requirement is. Some individual qualifications that only have some of the practice rights and not all of them, they can still make an application, and the exemption finder will give you tailored guidance for your qualification. But what they'll have to do is fill out the table in Section 8 and then against each competence provide a broad overview of the knowledge with specific examples. You'll have to provide redacted samples of work experience, redacted samples of your work, and provide corroborating evidence from your supervisor, so in the form of a reference. A key point to remember is that you will need to cross-reference your evidence in your examples, and the evidence must be equivalent to the level 3 of our threshold standard. So pre-qualification work experience is below that standard, and it must be at the level of a qualified lawyer.
Thank you, Manira. So you covered quite a lot of information there. So just to reassure everybody, there is detailed information about this on our website if you didn't catch everything that Manira covered, because there was quite a lot of information. The other thing, Manira, to talk about is that when somebody applies to us for exemption, presumably we have to make certain checks to make sure that they're eligible for that exemption. Can you explain to people what evidence do they have to provide?
Yep. So in regards to the level of evidence, the first thing we want to see is evidence of their qualification. So that can be an admission certificate or a certificate of good standing from their home jurisdiction. It's important to note that if the admission certificate or certificate of good standing is not in English, it must be translated by an official translated company, because we'll need to see that. They will need to provide a reference letter for their work experience. So for anyone who has to provide evidence of post-qualification work experience, we need a reference. And the reference letters, they must be written for the purpose of the application and dated within the last 3 months, submitted on letterheaded paper, and be provided for each period of experience claimed. The referees, what they'll have to do is confirm the dates that they supervise the applicants, and also confirm that they supervise them directly and what the arrangements were, and then include a summary of their role and what, just to give a brief job description of the level of work that they carried out. And they need to confirm that they review the application for the purposes of the application, the exemption application. With regards to the referee, we will need to see, if they're legally qualified, we'll need to see a copy of their admission certificate or a certificate of good standing. However, if the individual, if the referee is a Solicitor of England and Wales, we don't need to see the qualification evidence, because they just need to provide the SRA number, because we'll already have a record of them. If the reference is from a firm in the UK, the referee will need to explain that the work is done in their capacity as a qualified lawyer.
That's great. Thanks very much, Munira. Again, really helpful information, I'm sure, for everybody. Before we move on from you, Munira, I've got one more question for you. So, as I said, you deal directly with exemption applications. You must have seen lots of them. Can you tell us what's your top tip? What makes a good exemption application?
Yes, so my top tip for a good exemption application is just making sure that you've provided all the relevant information, and such as your qualification evidence and a reference letter if required. If you are required to fill out Section 8, make sure that your examples are a narrative and it's cross-referenced with evidence, and then your referee corroborates that in their reference as well.
Thank you. Sorry, Munira, I did say it was my final question, but I have got one more for you. Somebody's asked us about the cost of exemptions. Can you tell us how much it costs?
Yeah, so the cost of an SQE exemption application currently is £265.
That's great. Thanks very much. I'm going to come back to you now, Tim. We've had another question, which I'm going to ask whether you can answer. And somebody's asked, can you combine pre-qualification experience and post-qualification experience from different jurisdictions to help you get your SQE2 exemption?
You can, but what we would need is information from both those jurisdictions. And broadly, what we would look at is, say as has happened, we've had, for example, people who've qualified in one jurisdiction and then practice, and then they've transferred to another jurisdiction. We would need to look at both those jurisdictions to ensure that, first of all, the experience has been met, and also regarding the practicing rights, whether you are exercising the skills through the practice rights for those jurisdictions. So yes, it's not common, but we have had one or two where people have broadly transferred from one jurisdiction to another jurisdiction, and then as a third legal qualification wanted to qualify into England and Wales.
Thank you, Tim. And we've had a related question, which again, I think is very simple to answer, because it follows on from what you've just said. And the question is, can the 2 years be legal experience in England and Wales or only in your home jurisdiction? So I think you've sort of answered that.
I think the experience can be in England and Wales or in your home jurisdiction, but the important thing is that it must be in the capacity of a qualified lawyer. So if you are a qualified lawyer in your own country, let's say, you've come to England and Wales and you're doing work which is not actually sort of related to your actual qualification as a as a lawyer, then we can't count that because we've got no measure of what standard it's at. But on the other hand, if you are a lawyer from another country and you come into England and Wales and are practicing as a lawyer of that jurisdiction, then yes, the location in that case doesn't matter.
Thank you, Tim. And we've had another question in from someone who's asked, can they apply for an SQE2 exemption before they sit their SQE1 exams? So are there any time restrictions on when you can apply for that exemption?
There's no time restrictions. If you are a qualified lawyer of any other jurisdiction, you can apply now, and then you can sit the SQE, before you sat your SQE1 or whatever. The only thing that is important is that you must actually be qualified as a lawyer. You can't apply for an exemption on the basis of a qualification that you have not yet got.
Thank you, Tim. And we've also had quite a lot of queries from qualified lawyers who have also passed the legal practice course, the LPC, and they're asking, can they get exemption from the SQE on the basis of their legal practice course?
Yeah, thank you. Yeah, that's an interesting question, because we do get queries about this. And I'll deal with the two parts of the SQE separately. First of all, SQE1. The legal practice course is not the same standard as the SQE. The SQE is set at the standard of a newly qualified solicitor actually going into practice, whereas the LPC was designed to be done as a course prior to a training contract during which people would gain experience. Then it's therefore not set at the same standard as the SQE. And so, although if any individuals are out there who think that they have got appropriate sort of functioning knowledge to apply for an SQE1 exemption, then one of the pieces of evidence you can use for that is the LPC, but it is not in itself going to get you an SQE1 exemption. You would have to show a lot more in terms of your actual practical knowledge of the law of England and Wales. Then I'll come on to SQE2. The situation here is that under our current system, the SQE2 exemptions, they are there for qualified lawyers. Now, there is also a route which is designed, it's part of our old system. Under our old system, you had to do the LPC, and there are a lot of people who have done the LPC and then maybe have subsequently qualified in a different jurisdiction, perhaps. Because of the difficulty of getting training contracts, which was part of the old system, we do allow people to do the LPC and gain work experience and then sit SQE2 exam in order to test their skills. But that is not part of the new system, that is part of the old system. And under that system, there aren't exemptions. So you cannot, as it were, combine that old route, which is designed as a transitional measure for people who were part way through on the old system. You cannot combine that with the exemption system we use currently for the SQE. And there is information about that set out on our website, particularly if you look at the section about the LPC, you'll see all that's clearly explained.
That's great. Thank you very much, Tim. I'm sure that's helpful because, as I say, we've had lots of queries about the LPC. Munira, let's come back to you. We've also had a question in from someone who asks, what should they do if they're a qualified lawyer, but they've been removed from the register of their bar association because they've moved away from the country? What would they do in this situation?
So if they're still a qualified lawyer, they can make an application for an exemption as long as they can show evidence of their qualification, such as an admission certificate. But however, it is important to note that if this individual later wants to apply for admission as a Solicitor of England and Wales, we will need a certificate of good standing from their home jurisdiction. So at that point, when it comes to admission, they may need to then re-register in their home bar, to provide a certificate of good standing. so they can apply for an exemption.
Thanks, Munira. And Tim, back to you. We've also had quite a few queries from lawyers who are qualified through the CILEx, Chartered Institute of Legal Executive route, or who have qualified as a licensed conveyancer in the UK. Are the rules the same for these lawyers, Tim?
That's right. A qualified lawyer is someone.
Tim, I think you might be on mute.
Can you hear me now? Can you hear me now?
Thank you,
Yes,
Tim.
we
Yeah.
can. Yes.
Right. Yes, a qualified lawyer, as we've said, is someone who holds a qualification which gives them practice rights. And that applies in England and Wales as well as abroad. So lawyers who have a qualification that gives them practice rights, so that includes barristers, it includes chartered legal executives, it includes licensed conveyancers, any of the professions which broadly are part of that regulated framework of legal services. And there's an act, the Legal Services Act, which states what those professions are. If you're a member of one of those professions, then you are a qualified lawyer. However, when that makes you eligible to apply for an exemption, the thing is that if you go back to what we were saying earlier, I mentioned about practice rights and having the same practice rights, you would have to either have all the same practice rights as solicitors, which by and large, most, for instance, chartered executives don't have. They often tend to specialise in an area such as probate or conveyancing and don't have practice rights outside it, but it's possible to gain them all. And so either you've got to have all those practice rights, the same as for a solicitor, or if you've got limited practice rights, it's again the same as for a qualified lawyer from abroad, where your jurisdiction has not granted you all the practice rights. You have to fill in Section 8 of the form, and you have to show through that you have all the skill. You have to provide evidence to back up that Section 8 to show that you have all the skills that a solicitor of England and Wales does that are tested in the SQE2.
Thank you, Tim. We've had a couple more people just asking for clarification on, can you apply for an SQE2 exemption before you take SQE1? And the answer to that very quickly is yes, you can apply for an SQE2 exemption at any point. So finally, before we move away from exemptions, I'm just going to come back to you, Chris. We've had some queries about the English language requirement for qualified lawyers. Can you tell us what that English language requirement is, please?
Certainly. This comes back to what I was saying earlier about the SQE2 consisting of both written and oral tasks that test the practical legal skills. So if you pass SQE2, you will have demonstrated your proficiency in English or Welsh. But if you are granted an exemption from SQE2, then you wouldn't have demonstrated your language proficiency. So we would need to know before we admit you as a solicitor that you are proficient in English or Welsh. You can do this by providing evidence that your professional legal qualification, that is the qualification from your home jurisdiction, that you used for your exemption was assessed in English or Welsh, or by showing us that you have passed a language assessment at an appropriate level. Again, there's more information about this on our website.
Thank you, Chris. I'm going to move on now then from exemptions. I want to ask you, Chris, about qualified lawyers, about what they can do if they don't want to re-qualify as a solicitor in England and Wales. So qualified lawyers can practice in England and Wales without qualifying as a solicitor, can't they? But there are some restrictions. So can you explain that to us, Chris?
Absolutely. So England and Wales is actually quite an open jurisdiction for legal practice. This means that there are restrictions only where it's strictly necessary for public protection. For example, the Legal Services Act 2007 reserves some activities to solicitors and other qualified lawyers. These are the exercise of rights of audience. This means appearing in court. The conduct of litigation. This includes filing any paperwork with the courts in a legal matter. The conduct of criminal litigation. This includes advising clients at the police station and other matters. Reserved instrument activities. This means activities relating to the transfer of property. Probate activities, although preparing wills is not a reserved activity. And notarial activities and the administration of oaths. So many legal activities, including giving legal advice and practicing business law, are not reserved only to solicitors. And that means that you can undertake those activities without being a qualified lawyer. So you may decide that you don't actually need to become a solicitor because there are a lot of legal work that you can do in England and Wales without requalifying.
Thank you, Chris. And then we also have a system for registering foreign lawyers, which is slightly different from what you've described, Chris. So, Tim, can you just tell us about registering as a foreign lawyer?
Yes, as Chris has said, we don't require all qualified lawyers working in England and Wales to register with us. But if you do wish to become a manager or an owner of a law firm that we authorise, and that includes typically being a partner in a law firm, you will need to register with us because you become, in effect, one of the people that we need to regulate. And that you will then become what we call a registered foreign lawyer, or RFL. And there are full details about how to do that on our website, you know, it's a fairly straightforward process. Now, if you do register with us as an RFL, then you can do a lot of different legal activities. You can practice the law of your home state, and that includes legal work that's reserved to lawyers in your home state, as long as that's within the rules of your own profession, that they don't have any restrictions on your practice abroad. You can also advise on English and Welsh law, and you can provide either yourself or you can supervise other unreserved legal services, so anything that is not reserved by law to solicitors. And you've also got a certain level of practice rights in relation to immigration. You can act in first-tier immigration tribunal cases, and you can prepare documents for that. So that is a particular area where there is specific regulation to allow you to practice. So yes, so there is very much an option for you to either come in and practice on your own account, or to, if you want to, register as a foreign lawyer and become part of an English or Welsh law firm.
Thank you very much, Tim. Munira, I'm just going to come back to you for this this question that we have just had in. It's a question about lawyers from the Republic of Ireland and whether they have to apply for exemption.
Qualified lawyers of Northern Ireland and Republic of Ireland, they don't have to apply for an exemption. There's information on our website under the pathways to admission. So the pathways for qualification. There is information specifically for Northern Ireland and Republic of Ireland solicitors. So they just apply for admission, but they don't have to apply for an exemption.
That's great. Thanks very much, Munira. And then I've got one last question that I'm going to ask Tim of you. Someone's asking, can someone from another country take SQE1 and apply for exemption whilst not living in the UK?
That's right. Yes, they can. You don't have to live in the UK to apply, and you can in fact take SQE1 abroad, as Chris has mentioned. So you don't actually need to come to England and Wales in order to do that. We are always looking at, for both SQE, we're looking at the standard you reach, and for your for exemptions, we are looking at what your qualification confers and what experience you've got. The location is not a decisive issue for us.
Thank you, Tim. That's really helpful. I'm going to finish with the questions there. We've just got one final slide. We've obviously covered quite a lot of information in this webinar. So we've got one final slide there, which shows you where you can find more information. As we've said, there's quite a lot of information on our website. If you do have any other questions, of course, you can contact us directly, and we can help you with those questions. But I would urge you to go to our website first. Also, as I said at the beginning, we would really like your feedback on this webinar. We do read the feedback that you send to us. It's really helpful. So please let us know whether this webinar has been helpful, but also let us know if there's any other topics that you would like us to run webinars on in the future, because we do run these on a regular basis. But that then just leaves me to say thank you very much to everybody for watching today. We hope you found it useful. And as I say, please do fill out the feedback form, and thank you very much.